So welcome to the program plenary of the afternoon, in which we hope to end the afternoon with a bang and discuss whether the Supreme Court is a failure, and if so, what can be done about it. So this program is being recorded by C-SPAN, so you may find it at any random hour of the day or night for the next 5 years. So. Before I introduce our distinguished panelists, I have to go through my marching orders here. One of which is to introduce myself. I'm Linda Greenhouse. I teach at Yale Law School. I'm a member of the ACS board, and I'm very happy to be a member of the ACS board because I view our mission as helping to grow and sustain the next generation of progressive lawyers. And I've been delighted to see how many students there are and members of the lawyer chapters, and so that's why we're all here. But we have a diverse panel, so not everybody is necessarily on the same page, and that's obviously a good thing. Cell phones, please mention that cell phones must be turned off. Okay, done that. Okay, we'll have about 20-25 minutes of Q&A. At the end, that is to say, starting at about 20 minutes past 5, and there will be cards. And the cards will be collected. If audience members would like to tweet about the session or their national convention experience, the Twitter handle, the official hashtag is ACS15. And this session is approved for CLE credit. For more information, you should consult the blue CLE handout in your convention bag or the staff. Okay, so we're going to take, I hope, a kind of outside-the-box response to our topic of whether the Supreme Court is a failure. And by that question, we don't mean doctrinally. We mean structurally. We mean, well, we don't necessarily mean the problem with the Supreme Court is that one justice decides every important case. We can all agree that that's maybe problematic, but that's life. But there are many things we can talk about in terms of the Supreme Court's institutional functioning, the nomination process, the confirmation process, various other aspects of the way the justices collectively or individually approach their work. And what I've done, rather than ask people to give us a little set piece of a talk to start us off, is I'm going to throw out the question to our very distinguished panelists, who I almost forgot to introduce, but I will introduce. The question of just to name one thing that they think indicates whether or not the court is a failure and what they'd like to do about that, and we'll have a discussion of that, and then we'll move on to the next person. So in the order in which they're going to speak, which is not the order in which they're sitting. So on the far right is Larry Kramer, who is the former dean of Stanford Law School, and he now runs the Hewlett Foundation in the Bay Area. To my left, which is not where he would usually find himself seated, is Nelson Lund from George Mason Law School. At the far left is Erwin Chemerinsky, the founding dean of the law school at UC Irvine. And to his right is Elizabeth Wydra, who is the chief counsel of the Constitution Accountability Center. And Justin Driver on my immediate right from the University of Chicago Law School. And so these are all very distinguished constitutional scholars. And we're very lucky to have them here. So I'm going to start with Larry. Is the Supreme Court a failure, and in what way, if so, and what would you like to do about that?
So I have a talk I give, I was saying, called Why You Should Hate the Supreme Court, although it's too long for this. So whether the Supreme Court's a failure obviously depends on how you define success. So from my perspective, it's a failure because it has way too much power. And the amount of power that it's been given is insane within any democratic system.
In fact, you wrote a whole book about this.
I did
once.
write a whole book about that. But so, one solution would be take away their power. Since that's probably not so interesting here for a variety of reasons, an easier way to see it is that to the extent that it's going to have that power, there should be some balance for accountability on the other side. So there are independence provisions built into the Constitution, but we pile onto that a million more as though any attempt to make them sort of pay heed to anything that happens outside the court is bad. And so I'll talk about two of those just very quickly. So one is the lack of transparency about the way the court operates is shocking and extreme and ridiculous. And that, cuts across the board, whether you're talking about, their ability to take high-paid junkets without having to disclose them to anybody, their ability to decide themselves on discipline and when they will or will not recuse themselves, et cetera, across the board. So just the lack of television coverage in the court, which of course they oppose precisely because they really don't want too many people to see exactly what goes on, and on and on. So that would be one space. You can have a lot more transparency in what the court does and how it operates, which would, I think, change public perceptions of the court in a useful way without in any way actually significantly undermining, plausible notions of judicial independence. The other is if they're going to have this power, who we put on the court. I hope there's no justices out there or nearby, because this will be a little insulting, so be it. I'll preface it by saying I wouldn't put myself on the court either. But if you're gonna give people this kind of power, the fact of the matter is all the important cases the court decides, the ones that we care about, the ones that make it an important institution, are ones that literally by definition the law runs out in giving you an answer. So the question is, what's going to take you that last little, once you've sort of done the legal analysis and seen you can go one way or the other, what's going to take you that last little bit? And we used to actually put people on the court who had done things in life, had real experience and real accomplishments, who had been senators or governors or cabinet officials, who had had responsibility for making decisions in the political realm and seeing what the consequences were. And with that comes a kind of experience and wisdom. Now you take people like that, you remove them from the partisan context, and they can bring that to bear then in making those decisions when you have to make that last little bit. And as we made the Supreme Court more important, because this really starts around 1970, we of course stripped away the ability to put anybody on the court who'd ever done anything like that. So now in order to get on the court, you have to have basically been nothing other than a technical legal expert, and have not done anything beyond that. And of course the problem is then when the law runs out, exactly what it is these people have to bring to bear on the cases also runs out. And they have nothing else to bring to bear, and so they tend to fall back on what you would expect, which is ideology and supposition. And that's what you see. And I think the last justice, from my perspective, who had a kind of experience to actually bring to bear on this would have been Justice O'Connor. And you saw that in the way she decided cases, very distinctly, whether you agreed with them or not. And so we need that kind of wisdom. So I would change, and I don't know how you do this because it's really a cultural thing, but what we don't need on the court are people who have only ever been technical lawyers, and in particular the ones we get now, who have only been technical lawyers and never said or done anything, even as technical lawyers, that might cause any controversy, and instead have people who had real experience in the world that the court is going to affect through its decisions.
One other metric for that maybe is something that I remember Walter Dellinger said back in the day when he was advising President Clinton on potential nominations, is to ask whether that potential nominee, if they never made it to the court, would their obit get into the New York Times, and what would it say? And I guess by that measure, Ruth Ginsburg would qualify. I'm not sure of anybody else. But back to your points, Larry, you make two kinds of points. One's on the transparency and sort of with an undertone of ethics, and then on the kind of work product and who do we put on the court. So I think those are two quite different points, and maybe we can discuss them separately. And also on the transparency point, I think you make a couple different points. I mean, television is an old issue. One can debate, and it's been debated for many years. So maybe we can put that aside for the minute. But you mentioned judicial ethics and junkets and things. Is that a problem? I mean, they do disclose their their finances like every other federal judge, and they do hold themselves bound by the Code of Judicial Ethics. And as I understand it, the reason as a kind of formal matter the code doesn't apply to the justices even though they abide by it is because who would judge the justices, right? But do others think that these are problems that indicate that the court is falling short? Let's just look at the ethical part of the transparency, and then we'll peel the others.
Although, again, Linda, just to be clear about the point, it's not so much that you point to any particular thing that they would do as though that thing would make a difference. It's more about the overall culture of the court and the sense that they have of we can do what we want, or there is actually a public out there that's going to watch what we do. So when I take junket after junket paid by whatever the sponsors are, unions, corporations, pick your side, do I think about that? Do I think whether I do that or not? Does that affect how I decide? I have zero doubt that it does. Do I do less of it? So it's really a kind of pervasive culture in how the court operates and not so much a particular rule in the narrow sense of what it might change.
So is there sort of a corrupt culture at the court? Do people think so?
Again, it's not corruption. It's excessive independence. It's a sense that we don't actually have to worry about or care. So it's all interconnected. So if you're not going to take away judicial supremacy, which I would do, then what can you do nonetheless to give them some sense that they have to be accountable to the world outside? And that's what transparency rules are really about.
I don't think it's a corrupt culture. In fact, I think one of the great things about our federal judiciary, including the Supreme Court, is that rarely are there ever allegations of corruption. I think, though, that what Larry says is right. The ethical rules that apply to other federal judges should be applied to Supreme Court justices. I also think it's wrong to leave to each justice to decide whether to recuse himself or herself. I don't think anybody should be a judge for himself or herself, and I think a procedure should be changed where others are making that decision rather than the individual justice.
Who would make the decision?
I think we could create a panel of Federal Court of Appeals judges or some kind of panel that it would be submitted to. I don't like the idea of being submitted to other justices because I worry then they'll all just defer to each other. But it troubles me, and we can certainly identify cases where justices are participating even though there are serious questions, and we all know it's just left to that justice to decide. I think related to that, justices are often reluctant to recuse themselves because of fear that it would leave the court with a 4-4 split. I see no reason why we couldn't allow, especially now with 3 living retired justices, one of them to come back and sit in when one of the justices is recused, which I think may make it more likely that justices would recuse themselves in the close cases, and in the close cases it's better they recuse themselves.
So with your idea of an outside body of some kind, how would that work? So every cert petition would have to be vetted, every granted case would have to be vetted? What?
No, when there's a motion to recuse a justice, it should be submitted to somebody other than that justice. Who that body is, I'm less interested in. I'd even settle if it had to be going to other justices of the court to decide. But I don't like the idea that a person is a judge of himself or herself. And we have had instances where there were serious motions to recuse, and then the justice says, no, I think I can be fair. I'm going to stay here. I think of this, for example, when the Army spying case was decided by the Supreme Court in the early 1970s, Laird versus Tatum. And there was a motion to recuse Justice Rehnquist because he had participated in the issue when he was the Assistant Attorney General of the United States. And he said, I think I can be fair. Quite famously, there was the instance where Justice Scalia went hunting with the Vice President and then participated in a case where the Vice President was involved. And Justice Scalia wrote an opinion saying, I can be fair. And I can give other examples. I think it's much better when there's questions about whether a justice should be recused to submit it to somebody other than that justice.
Justin?
Yeah, so I do think it's possible to put Larry's comments sort of side by side and think about the way in which the justices are ubiquitous figures at law schools and on C-SPAN, and the sort of one place maybe that we don't see them as in their oral argument capacity. And I do find that distressing and sort of difficult to explain. It seems like justices, before they join the court, are often attracted to the idea of televising the proceedings in the court. And as you say, Linda, it is a sort of shop-worn argument about we need cameras in the courtroom, but why hasn't it happened? It seems like if the justices are going to go around and give talks, then they should be seen in their capacity. And I don't think that it's because people would be embarrassed about the proceedings at the court. I think that the justices ask good questions. It's an alert bench. So I don't think that they have anything to sort of fear by allowing cameras in the courtroom. If the argument is that it's about that justices or the lawyers are going to play to the galleys, I think that sort of thing already happens. So I don't think that would introduce a new dynamic. And so I think that it would be wise of the justices to let cameras in the courtroom. I don't think that there's a serious argument against it.
Can anybody think of an argument against it?
Well, I think the argument that the justices themselves make is that they're concerned that their comments would be taken out of context or something like that. But, we already have the audio of their comments, and, that doesn't really seem to happen that much. And I would say that it's perhaps a middle ground between the arguments against having cameras in the court is at least to have live audio of the arguments. I think that would help, especially, we see in some cases of very high-profile cases of intense public interest.
As they did in the marriage cases.
Right. Well, they released them earlier, but still later that day. And, as those of us who are members of the bar know, they pipe in audio into the lawyers' lounge for if there's overflow for the Supreme Court lawyers' bar section. And so it seems technologically very easy for them to do that. And, I think that would be a very good middle ground for the court to adopt if it wants to make itself more transparent. And I think that's only to the good if the American people can be more engaged and more knowledgeable about what the court is doing.
In a way, I think the current system is actually more problematic in that from time to time the court will acknowledge that there's a major case and they'll put out the same day audio, which puts the court in a very odd position of identifying the important cases. I mean, let's assume that every case they grant is important.
What's the difference between hearing the audio immediately after the argument, with C-SPAN putting still photographs of the justices and lawyers there, and watching it live 2 hours earlier? There is no distinction there.
Or, having it put to the John Oliver, dog reenactment session, which,
Right.
Like, is that better? I don't know. The dogs are cute.
Nelson?
I have a little bit different view on this. Larry said that one of the problems with the justices is they think they can do anything they want. And I think to the extent that that's true, it's a much worse form of corruption than any of the things we've been discussing here about recusals and televising the proceedings.
Yes. And do you agree?
Do I agree?
Do you agree that there's a problem that they can do anything they want?
Yes.
Okay. All right.
Now you're supposed to say what you would do about it.
I do have some ideas about that. And I could kind of give a little bit of background. I went and read all of the transcripts of the confirmation hearings of the last 4 justices. And when they were asked what they thought the role of the judge was, I found what they answered. And you couldn't tell the difference between the answers. If I read the answers, you wouldn't be able to tell which nominee it was. They all said exactly the same thing, that the job of a judge is just to apply the law to the facts. My personal views on anything have nothing to do with being a judge. It's a very constrained, narrow, legalistic role. And the 2 most striking cases were President Obama's nominees. Both of them were asked, well, the president said it's all about your heart. That's a really important part of being a judge, and that's why he picked you. And they said, oh, no, I don't agree with that. Both of them said they don't agree with that. So they say, and all of the senators seem to agree on both sides of the aisle, that that's what a judge is supposed to do. And I think it's not completely impossible that they could do that a lot more than they do now. Recently I saw a report of a talk that Elena Kagan gave at a law school where she described the conferences. And she said, well, there were really 2 kinds of conferences. One are the ones about the big cases that make the front page of the New York Times. And those conferences are very short. Nobody discusses the case at all. They just say how they're going to vote. And I guess she said they all think if they actually explain or discuss the case with each other, they would just annoy each other, and so what's the point of that? But then she said there are long conferences, and those are about the cases that nobody except lawyers who specialize in that field pay any attention to. And she said, often those go on for quite a long time, and they spend their time trying to figure out what the right legal answer is, and they don't come in with settled views and they try to work it out. So my proposal would be that Congress do a few things to encourage more long conferences and fewer short conferences. And I have 4 proposals, which I've worked up with my colleague Craig Lerner, and I'll just state the conclusions without giving any of the reasons. First, Congress could require all opinions of the Supreme Court majority, concurring and dissenting, to be anonymous, in effect, universal per curiam opinions. But that would include the concurrences and the dissents. Second, they could actually expand the jurisdiction of the court. Right-wingers often, go in for these jurisdiction stripping ideas, cut it down and let them do less. I would say let them do more. And there's a no longer used statutory mechanism by which courts of appeals can certify a question to the Supreme Court on issues that they think the lower courts need more guidance on. And the Supreme Court doesn't like to be told which cases they're going to hear, so they never, ever any longer accept these certifications. So my proposal would be, for every cert grant on a federal question case, they have to take one certified case from a court of appeals. And that will give them more opportunity to try to deal with the issues that the lower courts actually think they need guidance on. The third thing I would do is take away their law clerks, who have a very pernicious effect on the culture of the court.
That would break the hearts of half of the people in this room.
The law clerks just have a pernicious influence. To the extent that they serve a valuable function in doing research, that could be assigned to the office of the librarian of the court, and the results of that research would then be shared with all the justices, not just little research projects aimed at a particular justice, and these clerks in the librarian's office wouldn't be permitted to draft opinions at all. Now, right there, requiring the justices to write their own opinions would have some of the beneficial effects of term limits, because if they actually had to do their own job, we would have fewer justices who stayed in the saddle past the time when they can no longer mount the horse. And my last suggestion would be we bring back circuit riding. That was, for 100 years, they were required to do circuit riding by Congress, even though they hated it. They finally managed to get rid of it and bring it back. They've got plenty of time during the summer. They could spend a little less time in the Alps and more time sitting on some of the lower courts doing real judicial work. And I think these are all marginal changes, very modest proposals. They won't give us the perfect court. That would only happen if we appointed 8 more Justice Thomases, but it would be an improvement.
So these are wonderful blue sky proposals that I actually, you and Craig Lerner have an article which I assign to my students every spring in a course about the court. I wait till the very end of the term, so they have formed their own views, and then I present them with yours. And I think it's one of the favorite assigned readings of the whole semester.
Yeah, I'm often good for a laugh.
So, anonymous opinions. Of course, some of the European courts take a different approach, but I think approaching the same problem is they don't allow dissenting opinions, right? So you could have anonymous opinions that would speak for the entire court without concurring or dissenting opinions. Have you ever thought of writing a new article about that?
No, I wouldn't do that. I understand the European judicial culture is quite different from ours, and I actually think dissenting and concurring opinions can serve a valuable purpose, partly in disciplining the majority by presenting competing arguments, partly by informing the bar about disagreements within the court. What I think making them anonymous would do that insisting on unanimity wouldn't necessarily do is curtail a lot of the showboating. Many opinions nowadays are not written for lawyers. They're written for the New York Times. They're written for casebook editors. And there's a lot of stuff that, in my view, just doesn't belong in judicial opinions, in the opinions of many of the justices. And that's not a partisan or ideological thing. Anyone who follows the court at all will know who I'm talking about on both sides of the ideological divide.
So the dissenting and the concurring opinions would also be unanimous?
Yes, they would be
anonymous.
they would be anonymous.
Right. Anybody have a reaction to that?
Well, I think that I think having authored opinions is important, because if we had anonymous opinions, I think it would make the transparency problems that Larry mentioned perhaps even more pronounced, because I think it's important to be able to say, Justice Scalia authored this opinion, and it is in contrast to these 3 other opinions that Justice Scalia has authored or joined. And so I think that that's an important part of synthesizing precedent, and also allowing the public to hold justices accountable for if they deviate from precedent and from their own stated views before. So I think that not being able to do that would be harmful.
But that goes back to Larry's initial point. How does the public hold them accountable? Where's the accountability with life tenure?
Well, I think, I'm not saying that they're necessarily very sensitive to public outcry, but I think that, if one does take seriously one's role as a jurist, you want to be seen as principled rather than unprincipled. And if you just sort of willy-nilly decided according to your particular preferences as to outcome in that case, then I think there would be a sufficient outcry, as we've seen in cases where, I think it's been important to hold justices to say, you voted this way in race, you should vote this way when Obamacare comes before you. And if you don't, then maybe that's motivated by politics, and as opposed to a principled statement of the law.
Yeah,
Linda,
I could just
I think
respond to that.
ultimately the way we hold the Supreme Court accountable is through presidential elections and senatorial elections. Who we elect for president in 2016, especially if there are 2 terms, is likely to fill 4 vacancies on the Supreme Court. There should be no issue in the 2016 presidential election more important than Supreme Court vacancies.
I got to say, that statement, which is sort of true and is said a lot, is insane, right? Something has gone seriously wrong with your democracy when the statement that's made is what we really need to worry about when we choose a president and our members of Congress is who they're going to put on the Supreme Court. I mean, that is just, and this is not critical of you, Erwin, because I think it's an apt statement, and it is a really clear statement of what the core problem is. And I would absolutely get rid of the law clerks for exactly the reasons Nelson has. It's like, what do you have to make them? So accountability, the court is acutely self-conscious of the limits of its own power. The problem is where we have set those limits is so far out there that they can go really far. And so the question is, what are the devices that you can have to reproduce some semblance of modesty with respect to their views as compared to the views of lots of people who disagree with them? And so, as I say, I don't think that's incorrect, but it is just, whoa, what kind of democracy is that, where it's like the unaccountable branch that we have to worry about because they're going to make, like, democracy is great except for things that are important, right? Those things we have to give to this little oligarchy over here. That just seems to me crazy.
But I think the question is, are we as a society better off having an institution like the Supreme Court and the federal judiciary largely insulated from direct electoral accountability to define the meaning of the precious rights in the Constitution? And while I'm tremendously critical of the court over history, I still believe we as a society are better off with that kind of an institution.
We've debated this a lot, live in front of audiences too. Of course, we're not better off. And we didn't have that until very recently, and they have not across the course of American history. Actually, what always amazes me is that progressive audiences should hold this view so much more strongly than conservative ones. Because across American history, the court has been a reactionary institution far more often and in way more ways than it has ever advanced progressive causes. And you're living with that.
Just add this. The only thing I'd say is that when I think of the people who I've represented through my career, criminal defendants, prisoners, a homeless man before the Supreme Court, a Guantanamo detainee, For them, it is really the courts or nothing. And so to say we're not going to have the courts available, when is the last time a state legislature adopted a law to expand the rights of criminal defendants? When's the last time a state
Erwin,
legislature?
where are you living? They're doing it all the time now. So these things come in waves. As I say, what's amazing for progressives is the sort of delusional capture that a very brief and exceptional period in American history has put over the whole of American history. All of the progressive reforms in criminal justice that took place both in the run-up to the 50s and 60s, and there were actually quite a few of them. I mean, we tend only to focus on the things the Supreme Court did without paying attention to the parole reform. Where did that come from? The Supreme Court didn't do any of that. And what's happening now is all in the face of a really radical conservative Supreme Court on criminal justice rights, where we've actually finally, the one area in which we've got some breakdown and polarization is on prison reform and criminal justice issues. So you have to really do take the long view and not, you say the people you represented, yes, you were a lawyer during exactly that period. I see that. It's not that we have never had a period, but if you have to look at the course of American history, it's really hard to justify the court as a progressive institution, although that's not the basis for my view. I don't care one way or the other. I actually believe in democracy.
If I could go back to Elizabeth's point, which I disagree with, I think it's actually been a pernicious development that the justices feel compelled to stick with their own personal precedents. It used to be that the precedents were the decisions of the court, and oftentimes, very commonly, once the court decided an issue, the justices who were in dissent simply accepted that precedent, and that was the precedent of the court. In recent decades, we've seen an increase in this idea that each justice has to be consistent from case to case.
What some people call self-stare decisis.
Self-stare decisis, right. And I think that contributes to the court behaving less like a court. Now, it's true that I suppose if the opinions were anonymous, people could change their positions for political reasons. But they can do that anyway, because there's not a single justice in modern times who hasn't been able to hire law clerks who can figure out a way to distinguish away some inconvenient precedent for that reason or any other.
I agree with Nelson on the idea that the justices should not fear changing their minds as much as they seem to. It seems to be that causes them great pain to say that I've changed my mind. So one sometimes encounters rather elaborate explanations as to why they voted to uphold the statute in Bowers, say, and vote to invalidate the statute in Lawrence versus Texas. I think it would be better if people got away from that, but if they could explain what has led them to change their mind, I think that would be advantageous. On the question of accountability and how we hold justices accountable, I actually think that one of the ways that we hold them accountable is by having them sign their names to the opinions themselves, that they write a dissenting opinion in 1896 and that we can identify it. Justice Harlan wrote that opinion, right? Or that they wrote an infamous opinion on behalf of the Supreme Court. I think that it's helpful to be able to identify the particular justice that wrote that opinion. And I'm not even sure that it's actually possible to have anonymous opinions anymore, given the sophistication of computer databases that would be capable of sort of knowing who wrote the opinion. That takes us to the question of law clerks, right? And as to the law clerks, I think that law clerks, it's not all that long ago that I was a law clerk, I think that they actually at least are capable of adding something valuable to the institution, and perhaps what's most important is not so much the drafting of opinions to the extent that that happens, but instead it's the voice of a younger generation, right? Many of the justices are in their 70s and 80s, and there are frequently cases that come before the court involving technological issues or issues of swirling social import. I think it's incredibly valuable for the justice to have someone in their chambers that they can talk to about these sort of issues. So I would be very reluctant to get rid of the...
It's a really funny selection process for people to bring that particular expertise to bear.
So.
I got a lot of students at Stanford who I would, say, why don't we pick them if you want to inform them about technology or whatever the issue is, It's like law students who did really well in law school. I'm not so sure.
Yes, but you're
I'm one of them. Like I say, I probably shouldn't have been a clerk either.
Your mention of the age of the justices and the need or the utility of bringing young voices into their chambers, of course, raises the whole topic of life tenure. So I think there's a lot to discuss about about life tenure, and I'll just throw it out and see who'd like to get rid of it.
I would. I favor 18-year non-renewable term limits for Supreme Court justices. In part, it's because life expectancy, thankfully, now is so much longer than it was in 1787. Clarence Thomas was 43 years old when he was confirmed for the court in 1991. I don't want to sound ideological. Elena Kagan and John Roberts were both 50 when they were confirmed for the court. Imagine that these three justices stay until they're 90, the age which Justice John Paul Stevens stepped down. That's too much power to be exercised by a single person for too long a period of time. Also, too much now turns on the accident of history as to when there's a vacancy. Richard Nixon had 4 vacancies in his first 2 years as president. Jimmy Carter had no vacancies in his 4 years as president. 18-year non-renewal terms would mean that every president would have a vacancy every 2 years, and I think that would be far better.
Anybody want to take that on?
I don't have any objection to term limits. 18 might be too long, maybe 2 might be better. You could have rotating circuit judges serving on the Supreme Court for 2 years apiece. That might be even better.
I think that I'm opposed to term limits, and here are some arguments against them. One would be the Constitution of the United States, right? There is Article 3, Section 1, which talks about the tenure that justices have. So assuming that one were even able to have a constitutional amendment, which I think would be required to bring that about, and that seems incredibly unlikely, I worry about the costs of the constant churn of Supreme Court justices. If there are a turnover every 2 years, one could imagine the justices having even greater incentive to have these sort of strategic arguments about whether to hear a case or not to hear a case. And that causes me some concern. I should also say that some of our most distinguished justices served for more than 30 years. Think about Chief Justice John Marshall, and wrote some rather important opinions that shape our constitutional universe well after he'd been on the court for 18 years. And I think that that the same could be true of Oliver Wendell Holmes, right? So before we start thinking about imposing these tenure requirements, I think we should be really careful there. And one of the reasons we should be careful is because of I do think that it incentivizes justices to think about what they are going to do after they leave the court. And that seems like a mistake to me. Earl Warren obviously was Attorney General of California during the internment of Japanese Americans. And then he joins the Supreme Court and votes in a way that's very incompatible with it. I think that one of the reasons that he was able to vote in the way that he did as a justice on the court is because he didn't have to think about the next election or what was going to come after leaving the court. So that is to say that there is a real virtue in having people go to the court and understand that that's the last position that they're ever going to hold in their professional lives.
I think, so first, it doesn't require a constitutional amendment in the sense that I think the Crampton proposal actually, which functionally achieves this, does not require a constitutional amendment and is perfectly lawful. And then, you see the arguments on both sides. On balance, I think I would absolutely favor term limits. I mean, yeah, you have an occasional justice, but again, think of the justices over time who have served really long times, and the vast majority of them both don't do their best work in their later years, and more importantly, they're so out of sync at that point with where the country is. What I like about the idea of a regular turnover is it's one of the ways in which you can preserve strong judicial independence and even supremacy, and yet not worry about the court veering too far away from where the country is moving in things because there's the constant turnover. And then the question, which is a good one, I don't think a justice would have too much trouble finding a good job after stepping down off the court, but most law schools would probably hire them. But the confirmation process would have to change, obviously, but it probably would if it was every 2 years. I mean, the routinization of it itself would bring the stakes down for any single appointment.
Well, I think one answer to Justin's concern about losing the best work of the older justices might be that with regular turnover, there wouldn't be such an incentive to put the very young justices on the court. So I think one can make an argument that the framers' view was that service on the Supreme Court would be kind of a capstone and not something that would come early in somebody's legal career. You want to talk a little bit more, because people may not be completely up on the various proposals that are circulating. We'll leave aside the every 2 years, but looking at the 18-year, there is at least an argument that it could be done without a constitutional amendment if somebody got life tenure on the Supreme Court, but the actual active job of serving as a working day-to-day justice would be for the 9 most junior people of the group. Am I right about that, Erwin?
This is the proposal that Paul Carrington and Roger Crampton have proposed, and they say it wouldn't require a constitutional amendment. I admit here I'm skeptical. I think it would require a constitutional amendment, but here I may disagree with Justin about the impossibility of the constitutional amendment. When Rick Perry ran for president 4 years ago, he proposed just what I've suggested, 18-year non-renewable terms. When you have conservatives like Rick Perry and liberals like me both proposing it, maybe it becomes more plausible. I've spoken to a lot of audiences about this, and it's interesting that on the rare occasion I get interrupted with applause, it's for proposing 18-year non-renewable term limits. So I think there's really... I didn't do that on purpose. But I do think there's much more support for this than we might imagine. It would take time to build that support in order for it to turn into a constitutional amendment, but I don't think it's an impossibility here.
Nelson, you would mention your concern about the confirmation process and the hearings and so on, and I guess another people that support the 18-year term say is that that would mean every president would get 2 nominees. So that you would avoid the kind of entrenchment problem that fate, or the entrenchment issue that fate would devolve upon the lucky presidents or the unlucky presidents like Jimmy Carter, who had none. So there would be an expectation of regularity that might lower the temperature, lower the stakes somewhat of the confirmation process. Is that something that appeals to you?
Well, lowering the stakes appeals to me. Whether this would do much toward that end, I'm skeptical about. I think the high temperatures that occur at Supreme Court confirmation hearings since the Bork hearing are something fairly new and are probably contingent, on the fact that we have a somewhat closely divided court and that kind of thing. I think that's probably a more important factor in driving these things.
Elizabeth, I want to give you a chance to weigh in.
Yeah, I think that I'm not sure it would lower the temperature at all, because, part of what raises the temperature is the fact that these very high-profile, very important cases get to the court in the first place, which I guess Larry thinks is probably a bad thing just at its initial premise. But, that would still happen even if we had the 18-year terms. And so I think we would still have very heated confirmation processes. So I'm not entirely sure what we get out of the term limits, I guess. And, I think a perfect example of, counterpoint to the idea that justices toward the, if they've toward a long period on the bench don't do some of their best work or aren't, as keyed into current societies, our speaker tomorrow, Justice Ginsburg, she's the notorious RBG at the very end of her career. You can't get more embraced by the younger generation and current events than that. People are getting tattoos of her on their arm. And, if we'd had term limits, we might not have gotten some of her best dissents, I think, in Shelby County. And a lot of these things come by somewhat by accident of what cases come up when you have which justices. Jack Balkin did this sort of thought experiment of what would happen if we'd had the 18-year term limits, and he comes to the conclusion that Roe v. Wade would have gone the other way. So I'm not entirely sure what we necessarily get out of that.
Of course, I think Ruth Ginsburg is the one who said maybe Roe v. Wade should have gone up the other way. What you get is this. Again, it's not that there are not individuals. I will say that here I can speak with some experience. The term I clerked, which was the last term of Chief Justice Berger, I think 6 of the justices were in their 80s. And I will tell you, they were not all there. And it was not that the law clerks stepped in and we did what we wanted. We didn't, in a way that might have almost been better. What we did is we would extrapolate from their past opinions where we thought they would want to go, and there was not the same ability to say, no, that far and no farther, I don't think I want to go there. And you do see this. You see a lot of the elderly justices become exaggerated versions of their younger selves in their later years. And so again, you can't do this by anecdote exactly, but on balance, think about important things that you might want to construct for your own lives. And who do you want? Do you want the ability to get people who are at the very, very tail end of their lives and whose abilities are unquestionably declining? Or would you rather have people who are at the peak of their powers? And I don't think there's any question that in most important things we'd say, I think on balance I'll take the people who are at the peak of their powers. And that's, that there's no reason this should be different.
If we're going to assess the Supreme Court, one part of that has to be the Lochner era, because those 40 years were a terrible failure by the Supreme Court that did incalculable damage to people in society. And in large part, that was because justices had remained on the court far too long. And I think the advantage of 18-year non-renewable terms is saying that we will have new justices coming on the court, but still give 18 years, which is a long time to make a mark on the Constitution, and it still allows for a long learning curve.
Larry, I'm just curious, given the arc of your own career and your own scholarship, did that year of clerking, is that what gave you the view that judicial supremacy is overrated? And
absolutely. It was, and I will say part of it was I clerked for Judge Friendly the year before, and it was an amazing experience. He sort of approached the job the way I had been taught you were supposed to. And then I got to the Supreme Court, and anyone who clerked with me will tell you, I was angry the entire year. It was such a disappointment in every single respect. And some of it was the aging issues, and it had nothing to do with the ideological stuff. It was the way they worked. It was the suddenly sitting inside that bubble, realizing what an incredible bubble you were in, the complete unawareness of real consequences, just in the few cases where I thought I had some sense of what they were, and on and on and on. Now, I didn't come out of the court. It took me a long time to get to the views I got to, although it's interesting, Nelson probably won't remember this. We were in law school at the same time. He was a year behind me, and we had this argument at the time, and I was a staunch defender of judicial supremacy at the time, and he was not then. And so it
Still
took...
not.
Yeah. Well, so it took a long time to come around, and a lot of it was because of the kinds of arguments Irwin makes, which I don't dismiss blithely by any stretch, which is that there is a really hard judgment to figure there obviously are benefits from having the unaccountability as part of the mix, and the question is just how much do we need? And we've just gone way farther than we need to, was my view. So that there's some notion that the court is anything other than an 800-pound political gorilla, which it is, and always has been, even in its weakest periods. And so that we don't need to be quite so afraid of doing things that would, as I say, get them better information, make them more aware, make them think they need to be more aware, and so on.
How was Judge Friendly when you clerked for him, and how long had he been on the bench at that point?
And I do know it's true, he was 82, but here's the thing. I talked to a lot of he was just extraordinary all around, smartest human being I've ever met. I talked to the people who clerked for him way ahead of me, and there was still a decline. It's just he started at such a ridiculously high level. I used to think it must have been amazing to see him when he was in his 40s or 50s. It would have been scary. It was scary when he was 82.
Maybe it's worth pointing out that Judge Friendly decided not to go until his powers were gone.
He decided?
He decided not to stay on the court until his powers were completely gone.
Yeah.
Justin, if I understand some of your recent work, your view is that the court hasn't necessarily been counter-majoritarian enough, right? That's a power that the court has to, for the good, that it shouldn't be shy about using. So I want to give you a chance to talk a little bit about that.
Sure. So, yeah, I think that the Supreme Court has fallen down in vindicating the constitutional rights of marginalized citizens. Some people would say that's because the Supreme Court is fundamentally incapable of vindicating those rights, that it's just too fragile an institution, and when it attempts to vindicate those rights, it ends up making matters much worse, right? So it can't come to the rescue of marginalized groups. You hear this all the time with respect to, say, Roe versus Wade and Furman versus Georgia, the capital punishment. Even Brown, people would say that our sort of seventh grade conception of the court coming to the rescue of racial minorities is inaccurate because the nation as a whole was committed to racial egalitarianism. I think that oversimplifies Brown. The North was not quite the land of racial enlightenment that we sometimes pretend. But even perhaps more important than that, I think that the Supreme Court does have the capacity to vindicate rights, even for very unpopular groups, right? I mean, if you think about Kennedy versus Louisiana from 2008, a decision involving capital punishment for individuals who rape children, the court says that's unconstitutional, can't do it. If you poll that,
A decision based on a mistake of fact, but leaving that aside.
Yeah, right. If you poll that opinion, it's not a great surprise that people would say, the majority of people would say, yes, you can inflict capital punishment on those sorts of people. If you think about Texas versus Johnson, for that matter, in the First Amendment context, flag burning, if you poll that question, more than 80% of people will think, of course you should be able to have a law against that. Nevertheless, the Supreme Court steps in, invalidates those measures, and stands strong, right, even in the face of proposed constitutional amendments. And so if the Supreme Court hasn't done a good enough job, and it's not because it lacks the capacity, I think it's because of the personnel that's on the court and their desires and their constitutional visions not offering a capacious enough conception of to afford people those rights. And so when one looks back over the appointments from Earl Warren, which I think of as the beginning of the modern Supreme Court in 1953, through Justice Alito's nomination in 2006, there were 23 justices that were confirmed to the Supreme Court. 17 of those justices were appointed by Republicans. Only 6 were appointed by Democrats. And of the 17 Republicans, 10 of those appointments happened in a row. And so when one thinks about what the Supreme Court is capable of doing, I think it is mistaken to only look at sort of history and not think about what the Supreme Court could do going forward. I really do worry about people who are in law school today constantly hearing, don't file lawsuits, instead, go to the public square, go to the State House. That's where the real change is created. I'm not encouraging people not to go to the State House, but there are some people for whom going to the courthouse is the only option, and the court has stepped in and successfully vindicated rights on at least some occasions, and there's no reason to think it's an incredibly powerful institution, right? I mean, Citizens United is another perfect example of it as a powerful institution. I understand that you regret that power, but it is a powerful institution. The question is what that power is going to be used for.
Nelson, you mentioned when you were talking about the self-stare decisis problem that the court's not acting as a court.
Less so than it used to, right.
So is it acting, just to play off of what Justin was saying, is it a legislative, what is the court, if you had to identify?
I guess a kind of monster. It really is two courts, and I think what Justice Kagan said at this law school talk, I think, is a sign of that. There really are two courts. There's the political court, and then there's the legal court. For a variety of reasons, the legal court is smaller than I think it should be, and the political court is much bigger than I think it should be. Maybe if they had different justices up there more in accord with my views of how to interpret the Constitution, I'd feel differently, and it'd be fine to have a political court, but I don't think so.
I very strongly disagree. I think the assumption in that statement is there's such a thing as value-neutral judging, that there can be law apart from value choices, and that's just impossible. When you're dealing with the Constitution, you're dealing with a document written in open textual language. What's cruel and unusual punishment? What's due process of law? There's no way to decide that without value judgments. Also, no rights are absolute. There's no protection of any class under equal protection that's absolute. Inevitably, there's balancing. We call them in law levels of scrutiny. So the court has to decide if it's a fundamental right or a racial minority. Is there a compelling government interest? Such as, is diversity in the classroom a compelling government interest? Even if it's rational basis review, the court has to decide, is there a legitimate government interest? So in the marriage cases, even if the court chooses rational basis review, They still have to ask, is there some legitimate government reason for keeping gays and lesbians from being able to marry? And I think the answer is obviously there is no legitimate government reason. But still, all of these require a value. My point is that all of these are legal questions. All of them require a value choice. And there's no way of having value-neutral judging. So it's a mistake to say there's two courts, one that's political and one that's legal. It's all legal, and it all involves some value choices.
Well, one thing that's interesting is that there's social science research that indicates that the public understands that, so that although there's a political culture that forces judicial nominees to say, as Nelson said, my job as a Supreme Court justice is to apply the law to the facts, the public knows that's not true, and they're okay with that. That you can hold two thoughts, that you in a way the public seems to want judicial nominees to say that, let's assume, or else they wouldn't be required to say it, the politicians wouldn't require them to say it. But on the other hand, the public well understands that judging is a value-inflected task, right? Elizabeth, I haven't given you enough chance to weigh in here.
Yeah, I don't know that the public is necessarily okay with the court acting like just another political entity. And I think that sometimes when
No,
we
that's not what I was saying.
Yeah, but I think there's an understanding that the justices have thoughts and experiences and so forth, and I think maybe getting an increased diversity of those experiences. Talking about we talked about Justice O'Connor as the last sort of justice who had state legislative experience, and so maybe getting a diversity of experience with more public defenders, fewer prosecutors, more folks who've been in public interest, fewer people who've just been in law firms. Maybe that would help. But I think that the idea of the court, as Justin mentioned, as a protector of rights is something that we shouldn't overlook. And the idea that you can achieve things in the court that you couldn't through the political process is incredibly important. Today is the anniversary of Loving versus Virginia. And while it's true that, most of the states didn't have bans on interracial marriage on the books, there was still a hardcore group of states that would not have done this, I do not think, without the court stepping in. And I think that's really important to note, that even if the court is not necessarily leading on these things, and many would say in the marriage equality cases this term, they're not leading, but certainly there are states that will not, without the court telling them, recognize these constitutional rights to equality. And I think that's a really important role of the court that Justin mentioned.
I think that's all of this is completely fair, though. What's bizarre is the impossibility to have any nuance in this debate. And I don't mean this debate, I mean the debate that we're having in society at large. So Nelson's position, I don't think, is that there is some completely value-neutral, free analysis that you use, and unless you do that, you're doing something wrong. On the other hand, there is a big difference in the relative mix and when you take a case and how you decide it based on that, because there also are legal considerations. So I think I feel pretty comfortable saying 20, 30, 40 years ago, at almost no other time would a case like King v. Burwell be in the Supreme Court. It's ludicrous that it's there, much less that it could possibly come out the other way. So it tells you something has gone seriously wrong. And the thing that has gone wrong is we seem incapable of saying that the court should have a role without saying now we have to hysterically protect it to enable them to do anything they want. So Brown is interesting because at the time Brown was decided, there's no question that the idea of judicial supremacy was not established as part of the background political culture. And you see it reflected in the pushback at the time. And what you got, what made this work, was not that the court had no role, but nor did it do this. It's the culmination in the legislation that you get in the mid-'60s, the Civil Rights Acts, of which the court is one piece, but so is a popular political movement that has nothing to do with the court. So the notion that you don't want people to, and you didn't say this, go out into this, to be engaged in the political side. So the question is, how do we find a balance where we don't have to say the court is going to be our protector of rights, and therefore no matter what they do, no matter how unprotective it is or how undermining it is, we have to protect their authority because someday we hope maybe they will do something that we like, or every once in a while they do. I remember Robert Post showing me when he was doing his Holmes Devised volume, when the court decided, Pierce and Myers, they sent those opinions around to the editors because it's like, see, we're not always conservative. Here's a liberal one. And that's a way in which the court does this. They'll toss a bone and then use that to do 25 other things. And again, that will go both ways. So this is not whether you're liberal or conservative. So the question is, can we have a system, as we actually did through most of American history, where we can have pushback? And what we want to be talking about, what are the devices to push back, right? What are they? So the things Nelson lists, I think, are great. I also, jurisdiction stripping, I think, is great. Budget slashing is fine. Court packing is fine. Who did this in American history? Jefferson, Jackson, Lincoln, Reconstruction Congress, Teddy Roosevelt, Franklin Roosevelt. Not exactly a rogues gallery, right? It's only in the last 50 years that we've moved to the position that no, what judicial independence must mean is that any of those devices, all of which are plainly constitutional on the face of the Constitution, any of those devices are such a threat to what the court's going to do that we can't do it. So we need to be balanced and recognize that the pushback has to come both ways. Sometimes the courts can push. Sometimes we need to be able to push back. For every Brown, there is a Citizens United, and the notion, or a Bush v. Gore, right? It was the day after when Gore comes out and says, well, you may disagree with the opinion, but it would be unpatriotic to do anything other than acquiesce. It's like in 1876, that would not, same dispute, right? That would not have happened. And so the court didn't feel that it had the ability to step in, even though there were people pushing it for it to do that at the time. So it's that dynamic that we need to be aware of. And so we do need some devices. I mean, I think that it's good to talk about what they are. Term limits are a possibility. They play some role. But we have moved in our public debate so far from that. Right? I mean, honestly, my view, it's depressing sometimes that my fans are Ralph Nader and Newt Gingrich. It's like, well, that's got a left-right thing, but that's not exactly where I'd like to be on either one. And something is wrong when the notion of challenging judicial supremacy is so fringy, and then this is what you get.
I think it's not an accident that the notion of challenging judicial supremacy is a fringe phenomenon. We shouldn't leave the story off in the 1930s, right? We have to think about the 1950s and about Brown, and there was pushback, as you say, in the form of most prominently the Southern Manifesto, where a group of Southern congressmen and senators get together and offer their own sort of constitutional interpretation. It's an incredibly legalistic document. And, one can use that to stand for the proposition that, well, judicial supremacy may not have been so widespread, but that makes lots of people incredibly uncomfortable when individuals are taking the Constitution in their own hands. Moreover, I think that the notion of judicial supremacy was a good bit more widespread in the 1950s, as judged by the result of the Southern Manifesto. People responded in really strong terms and said, who are you all to offer your Constitution? Your constitutional interpretation doesn't trump that of the Supreme Court. That is, Eisenhower says something to that effect, and many other senators said this, and newspapers all around the country said, who do these guys think they are? And so it's not an accident that given our sort of modern historical moment that many individuals are made uneasy when they say, I don't care what the Supreme Court says, I'm going to go ahead and do it.
Of course, that was always true. That was true when Jefferson was president as well. That is to say, there's always been this debate. There have always been people. Typically it was, so just very quickly, the judicial supremacy position through the vast bulk of American history was the conservative position. Just pick who your conservatives are, but whatever was the conservative, that was the progressive position was always in favor of democratic authority. And all that happened after Brown, and it takes time, is the left flips and the right doesn't. That's where the debate shifts from a debate over who has interpretive authority. Suddenly, for the first time really, beginning in the 60s, the debate shifts to how do you interpret the Constitution? Because suddenly the stakes are so high at what the Supreme Court is going to do. But that is a new development, not that there had never been both positions before, but the dominant position shifts, and it shifts because the left, in what, from my perspective, is a short-sighted action, flips on this idea, and now suddenly we have agreement from left to right that it's the court that should tell us what our rights are and what the Constitution means. And now we have to wait for someone to die or retire or get tired of the job or amend the Constitution, which is nearly impossible, in order to overdo or undo what they've done.
There's a little bit of flipping going on today, seems to me, on some of the barriers to jurisdiction, like standing. So in the not too distant past, it was liberals who wanted very generous ideas of standing, and now all of a sudden, basically any plaintiff, the plaintiffs in King against Burwell, who were about as sketchy as they come, let's not investigate their standing. Let's not question that, or let's not question the standing of Abigail Fisher to bring the Fisher case, even though she already graduated from college and there's no redressability prongs of the standing doctrine and so on, and maybe that reflects a bit of what you're talking about, Erwin.
Yeah, but I think there you have to separate the litigants' choices from the court decisions. I don't understand why the University of Texas didn't challenge Abigail Fisher's standing. I don't know why the Solicitor General's office didn't bring a challenge to standing in King versus Burwell. So there it's not the Supreme Court, it was the litigants' choices. In terms of the Supreme Court, I just want to be clear, we shouldn't think of the Supreme Court as all of a sudden liberalizing standing. Think of the last major standing case from the Roberts Court. It was Clapper versus Amnesty International 2 years ago, where the Supreme Court ruled 5-4 that no one would have standing to challenge a federal law giving the National Security Agency the ability to intercept communications between those in the United States and foreign countries. And the reason was that no one could show that their communications were intercepted or likely to be intercepted by the NSA, because the NSA doesn't tell people when it's intercepting their communications. That is a terrible decision in terms of standing, very restrictive, and that's the most recent one.
When some of you all were clerking, the court took about twice as many cases, or even more than twice as many cases as it's deciding today. But from some of the things I'm hearing, maybe they're still taking too many cases. What do you think? The court deciding too much?
No, I think they're not taking enough cases. They're just taking the wrong kinds of cases. There are lots of important decisions that need to be resolved. A professor named Arthur Hellman did a study of the court's cert granting practices, and what he found was that there seems to have been a cultural shift on the court away from an obligation to resolve circuit splits. Now, they can always find some way of saying, well, it's not a true split and all this kind of thing, but if I recall correctly, he suggested that Justice White was the last justice on the court who really took that obligation to clarify the law where there are circuit splits, take that obligation seriously, and he suggests with a lot of data that that's pretty much gone now. And I do think that's unfortunate. They should take more cases that actually involve more law and less politics without suggesting that you can have a pure version of either one ever.
I don't think it matters. I think what I said at the beginning is there's a reasonable number of cases, and they probably could take more, that really actually are technical legal cases. You need somebody to resolve them. The Supreme Court is fine for that. They have that expertise both as judges and they have the law clerks for them. And then in any given term...
You guys want to get rid of the law clerk.
Well, I think they would also be able to do it for other reasons, though, that it's a second batch, which is in any given term, and it doesn't matter whether there's 75 or 150 cases there on the merits, there are 4 or 5 typically that are the big cases, and that are why we're here. They're the ones that we care about. And there would be those, in either domain. So I don't think you're going to affect the fact that, there are these momentous issues. The Supreme Court has assumed, and always had to some extent, a role in helping resolve those issues. And I don't think much would change, as I don't think it changed in the move from 150 to 75 cases.
I agree, it wouldn't change much. It would be a marginal change.
Yeah.
But you think every circuit split ought to be
Well, depending on how you define a circuit split, that would probably be impossible, although I should point out that there was a time when the Supreme Court decided hundreds of cases every year with no law clerks. So this is not...
And with no opinions.
Well, they decided the cases, though.
Right.
They decided the cases. I mean, they were acting like judges. That's not an impossible thing for them to do.
Are there any kinds of cases that the court is ducking or failing to take note of that they should take?
Second Amendment cases. They recently denied cert in a Second Amendment case, and it drew a dissent from Justice Thomas and Justice Scalia. A dissent from the denial of cert.
Okay, more Second Amendment cases. Anything else?
I'm not going to identify a systematic category. It's instead, I think, every time there's a conference, I see cases where there's a real circuit split that require resolution, and then inexplicably cert is denied. This year, the court had oral arguments in 68 cases. Last year, the court decided 68 cases after briefing oral argument. The year before, it was 73. The year before that was 65, which was the smallest number in any year in my lifetime. As Nelson points out, as recently as the 1980s, the court was deciding 160 cases a year. I think there are cases where there's splits among the circuits, and the court is just not taking them. I also think a pernicious consequence of the smaller docket is the opinions have gotten much longer. I can at least show you an inverse correlation. As the number of cases goes down, the length of the opinions goes up, and I don't think that's led to better analysis or better opinions.
Well, in slight defense of the opinions, and I think also in defense of the, there was some criticism about the opinions maybe not being written for lawyers. In defense of interesting and maybe perhaps long opinions, I think that is one of the rare instances where we do have some transparency from the court for the public. And if that is the way that the public generally gets its information about what the Supreme Court is doing, then I think having those opinions being written in a way that is both interesting and understandable for the public is only a good thing. And I would note on the cases that the court should be taking, I think there are cases involving criminal defendants' rights that the court is not necessarily taking. And I don't know if that's because they're not interested. But I distinctly remember a day, and partly because this was my cert petition, the day that the court granted the case about the destruction of fish and whether that counted as evidence destruction. They denied a cert petition where there was a circuit split on whether you can have a non-unanimous jury sentence a person to life at hard labor. And I think that's a clear constitutional violation. And I really wish the court would have taken that. And I think that some of these cases involving, they're not sexy social issues, they're not high political issues, they don't have big business interests behind them, but they implicate incredibly important constitutional values, and access to courts are really important.
One area that I would identify as involving cases that the court should take more of but seems to be reluctant to take them on would be in the context of student rights in the elementary and secondary school context. The court hasn't heard a case involving student rights in the last 6 terms. During the Roberts Court, the Redding case and involving the strip search and the Fourth Amendment, and the so-called bong hits for Jesus case, right, involving student speech, along with the parents involved case. So there are 3 sort of major cases that the court has decided, but it seems not to want to get involved, and there are lots of sort of discussion about the Supreme Court is ill-equipped to be able to get involved in this arena, but this is a place where I think that they shy away from getting involved, perhaps because sometimes these cases are incredibly contentious, because when we think about our schools, we're thinking about who we are as a nation. But I think that effort to stay out of that matter is mistaken, because the lower courts do need guidance from the Supreme Court in order to be able to deal with these cases effectively.
Can you give us a couple examples of the kinds of cases that are being cert denied in that area?
Yeah, so one of the major issues in the area that the circuit courts are at odds about is speech that happens outside of the school context, on a home computer, say, or in some other way that ultimately comes back into the school, right? And so that doesn't fit into the traditional doctrinal categories in any way. And so that is one of the major issues. There was a case involving religious speech by students, right, about homosexuality, and these are really difficult cases, but they are common in the circuit courts as well. And so the court seems to not want to just get involved with that at all. There was a case that the court denied this term involving students wearing the American flag to school in the Ninth Circuit, and being told that was impermissible. That sounds obviously insane. The exact context was on the day of Cinco de Mayo, and this was seen as a sign of, sort of rebellion, and maybe even, so that was a very divisive case in the lower courts, and it seems like there would be a place for the court to step in and get involved in this area.
Larry, is that the kind of case we need the court for?
I have no opinion on this. I don't. It's one of these areas where I don't think I know enough to really say.
So you had mentioned court stripping as a valid way of constraining the court if
Jurisdiction stripping,
the public so desires. The most recent occasion I can think of for that was when some people in Congress got concerned that the court was relying too much on, quote, foreign law And there was a House resolution that was passed, I think not with the expectation that it would result in some serious piece of legislation, but as a kind of expressive protest that the court and any justice or judge who cited, quote, foreign law should be impeached. So, you know, it's kind of come down to that. But what about court stripping as an appropriate constraining mechanism?
What then would stop Congress from adopting an unconstitutional law, even a blatantly unconstitutional law, and precluding the Supreme Court and lower federal courts from being able to review it? And if Congress can do that, then we really have lost what the judicial branch is there for and what Marbury versus Madison created. Larry also mentioned another example when he said jurisdiction stripping, and I don't want to skip over it. You mentioned the possibility of budget cutting. And just yesterday, the Kansas legislature passed a law that said if the Kansas Supreme Court decides in a particular way, the funding for the Kansas Judicial will be stripped. If anything is a violation of separation of powers, it has to be that.
So I just want to jump in again. If you have a really simple-minded, and I'm not calling you simple-minded, I always hate when people do that, but a simplistic conception of the way democracy works, that sort of way of thinking about this matters. So this is where looking in the past is helpful. Because again, the idea with these devices is once the threat of them is realistic, you seldom need them. Because the court is acutely conscious of how far it can go. And what happens, the jurisdiction stripping proposals were routinely introduced in the early 19th century. They almost never pass, right? And that was not because of judicial supremacy. It's because, as I say, the court, if they go about their responsibilities responsibly, actually is an 800-pound gorilla in politics. They play the judicial role in the judicial way, but there is a difference between sort of, I did a talk with Justice Breyer where it was clear what he took pride. He was proud when he could say what I'm doing is absolutely what everyone else in the country thinks is bad and wrong. And that struck me as, no, yes, we want your independent judgment, but it should be in light of like what the rest of the country thinks, because after all, it's not they're all idiots either. And so the way democratic politics actually works is these things become the point of engagement where these issues are actually then flushed out. So when I think about the Southern Manifesto, for instance, it started a debate, it didn't end one. Right? It provided the grounds on which you had real public engagement that produced, along with a lot of real political activity, the Civil Rights Act of 1964. And that was so much better and such a better solution. And you don't get that when the court is effectively deemed to be a shutter off of politics. Now, it never completely shuts it off. We still see a lot of debate. But the way people respond to the court isn't just a product of whether they agree or disagree with its outcomes. It's also partly a product of the extent to which they feel entitled to disagree with it. I treat my boss differently when I disagree with him or her than I do my subordinate when I disagree with him or her. And whether the court sees itself as our boss or our subordinate will affect profoundly the way it operates. And as I say, if you look historically, I think you get a better balance with these devices being available. Not that you can't imagine the parade of horribles, but they don't seem to happen. And instead, we got some reasonable responses. The Marshall Court in the 1820s didn't stop being the Marshall Court, but it pulled back. And probably to the benefit of the country, pulled back in the face of the introduction of all these kinds of bills. So it's the availability of the threat. It's not the ideal way to do it. I think the Europeans have better ways. It's just, this is what our Constitution leaves us, because when it was written, none of them remotely imagined the court playing this kind of role. So they put this strong judicial independence in there, thinking of a different problem, the English common law history problem of, come in and say, I don't care if he's guilty or innocent, I want him convicted. So we wanted to make that impossible in the individual case, and they were stuck having to cobble something together. So term limits, supermajorities for appointments, easier amendment, there's all sorts of devices you can use. These are the ones we have. I would say I would rather have them than nothing, because when you have nothing, what you get is this court.
I guess we're having cards collected if people have questions.
Well, I just want to pick up before we get to that
No, please.
On what Larry said. And, I think that part of what your comments reflect is that things actually are kind of working now. We do have these pushbacks from the other branches. And, we have, when Congress doesn't like what the Supreme Court has done, for example, the Ledbetter decision, it passed a law. We have the president, able to say after Citizens United to the American people in the State of the Union address, this decision has deleterious effects. and it's a problem. And he's speaking to the American people in a way that he is empowered and entitled to do so. And, I think when I think about this question of whether the court is a failure or not, part of it is self-interested on my behalf of saying that it's not, because I have devoted my career to litigating in front of the Supreme Court. So if I think it's a failure in an illegitimate institution, then I might as well just not get out of bed in the morning. But, I think that, it in many important ways, it isn't a failure. And part of that is because it is the independent judiciary that our founders put in place instead of some of the European or the English model that wasn't as independent. And the legitimacy of the institution is reflected in the fact that I think the American people view it as legitimate, even when they disagree with it. Even when Gore comes out the next day and says, I disagree with this decision, but I'm going to stand by it. And in some ways, that is an institutional success, I would say, when you're looking at an independent judiciary. But I think, it only continues to be that way if there is some sort of idea that the court acts according to the law and not just politics. And no one has said this more often than Chief Justice Roberts, who says he doesn't want the court to be considered to be just another political entity. Of course, I think we have a lot of instances, and even in the Roberts Court era, where that hasn't seemed to be true, where you have in Citizens United the court reaching out to something that they didn't have to decide. And King v. Burwell, it will be another major test. When you have scholars from across the ideological spectrum saying there is no legitimate method of statutory interpretation that leads you to rule for the challengers, that's certainly a test of whether the court is going to follow law or politics. And I think that's something to watch to see whether or not the court is a failure or not. But I think right now, I would be sort of the voice of optimism saying that it isn't. We might disagree with it a lot, but I think institutionally it's not a failure, and it steps in, as it did decades ago on this day when it issued Loving versus Virginia, to vindicate the Constitution and individual rights.
Our conversation has provoked quite a few good questions. So maybe I'll turn to those in our last 15 minutes or so. One question is, are there lessons or reforms from state Supreme Courts that could inform the federal Supreme Court?
I'll give an example. A number of states have a merit selection system for their Supreme Court justices that I think any president could voluntarily create. And so what a president could do is create a commission, bipartisan, and say he wants names, 2 or 3 at least, supported by 2/3 of the group, and he promises either to pick from those names or ask for additional names. As an example, Alaska has used this system to tremendous success. So Sarah Palin picked a person, Morgan Christen, to be on the Alaska Supreme Court, who Barack Obama then put on the Ninth Circuit, and many think she's one of those liberal judges that he's placed on the Ninth Circuit. Jimmy Carter created merit selection for his federal district court and federal court of appeals appointments. And I think I can make the argument for his federal court of appeals appointments. They were certainly among the best, at that point the most diverse in American history. And I think that he might have done that for the Supreme Court had he only had a Supreme Court vacancy. This wouldn't take a constitutional amendment. Any president could create such a merit selection commission.
Any response to that? Or any other ideas from the state courts?
I have one question, which is, would the merit selection system lead to the potential nomination of the sorts of people that Larry was speaking about earlier, the public figures, the senators, and other folks who have played an important role in public life, or would it instead lead to the more traditional way of judges on the courts of appeals being, in effect, the farm team for the Supreme Court? Because, like Larry, I am drawn to the old model, and it's hard to imagine, say, that Governor Earl Warren would have been on anyone's merit selection team, right? He was not a distinguished law student, and people made fun of him even during his own time. So I guess that's one concern about the merit selection system.
Merit can certainly include life experiences and political experiences. Merit doesn't have to be so narrowly defined. And so I think a merit selection system likely would have produced John Roberts and Ruth Bader Ginsburg. I don't think it would have produced some of the other members of the court necessarily. And I think it could produce another Felix Frankfurter, who had come from being a law professor, or Hugo Black from the Senate, or Earl Warren from a governorship. I think it depends on how we define merit, and maybe creating such a merit selection process would cause us to have a discussion of what we mean by merit, and that would be a good thing.
Here's another state court-focused question. We've talked a lot about the failings of the appointment lifetime tenure system, but the majority of state courts have elected judges, and many have term limits. Those state judges are subject to attack ads, especially with regard to being soft on crime. What is the answer to judicial impartiality? So I take it this asks us to reflect on the dangers of the election system for the state courts. That's not quite our topic, but we certainly have seen recently in the state courts. Wisconsin is one example of the mess that was created up there in the recent judicial election and the unseating of Chief Justice Abramson. Terribly messy situation. Does anybody have thoughts about whether electing judges has any merit to it as an idea?
Well, I think I agree with Justice O'Connor on this, in that it's a pretty bad idea to elect judges. I think we've seen in the states some of the problems which the person who submitted the question points out, and I think that it also, to me, raised in my mind why some folks who criticize the court want to make it more like the democratically elected branches. I can't imagine right now, and I know we want to take the long view, but I can't imagine anyone saying, even with all the problems with the Roberts Court, saying that it should be more like this Congress. Like that's a good thing. It doesn't seem like it to me, and I think that that's something to keep in mind when we're thinking about what are the better alternatives here.
So let me just to be clear, I certainly wouldn't argue that judicial elections have been a good thing. It is worth remembering where they came from historically, right, which is in the early years when, again, it was the same fight over who controls the law. The Jacksonians made a move for codification. They had trouble with that, and so they moved to judicial elections as a way to make sure that the people who were controlling the common law would be somewhat subject to control by the democratic process. The interesting thing is, by the way, judicial review takes off. Once you have judicial elections, it takes off in the state courts, establishes itself as regularized, and then gets picked up in the federal courts much later in the post-Reconstruction era. So there's a certain irony there in terms of where this idea comes from. But the way elections have played out, it's not a good thing. The notion of accountability, there are all forms, all different ways to produce accountability and a balance of independence and accountability. The amazing thing about the founders when they constructed the Constitution was they thought this through very carefully, and each of the branches of government actually has a different balance. The long terms, the election by state legislatures. So we have lots of options. So no one's arguing that what we want the Supreme Court to do is to be elected the way Congress is, but that's not to say that therefore we have to go all the way to the other extreme. The other point that I would say, because I get this pushback now a lot also, is Congress, are you serious, right? What could be, and nothing could be worse than Congress. I do agree with that. We're spending $50 million at my foundation just to try and see if we can figure out ways to help improve that. But the point is, if that's the problem, then the solution is to fix that, not to give up on it and, again, turn your lawmaking over to an oligarchy. I mean, I don't get that part of it. Never did.
FDR tried to add more justices to the Supreme Court. Would adding more justices solve problems or create more problems? So, of course, we're used to having 9 justices. We've had 9 justices throughout the 20th century anyway, but there's nothing in the Constitution that tells us how many justices Congress should designate. So we have the right size on the court? Does it matter?
I don't think it matters.
No?
But you can manipulate. Again, the court packing thing, when Lincoln gets elected, they increase the size of the court because they want him to have more say. When he's assassinated, Johnson gets elected, they shrink the court. When Grant is elected, they increase the court again. So that's, those kinds of manipulations. FDR's court packing was completely successful. But you have to look at it not in isolation. It was part of a package of pressure that the court responded to that you wouldn't have today, because people saying the kinds of things that were being said in Congress in the 1930s would be shouted down across the spectrum. And that's why, yes, there is some pushback, but it is so tepid. Just President Obama makes this one little offhand comment about Citizens United, which is so tepid, and wham, he gets slammed by everybody left to right. How dare you criticize the Supreme? I mean, that is a long way. Go back and read the congressional debates around the New Deal, and that's a robust debate that doesn't exclude the possibility of judicial review, but also doesn't assume the court having say over the meaning of the important provisions of the Constitution.
This question maybe is related. What would the court look like if Senate confirmation was no longer required? Required, of course, by the Constitution, but setting that aside. What about the blue sky idea of just getting rid of Senate confirmation? Let the president.
It would look more like Congress.
Any thoughts on that? Okay.
If there was no Senate confirmation required, I think we've got to remember historically that in the 19th century, 20% of presidential nominations for the Supreme Court were rejected by the Senate, almost always on ideological grounds. And in the 20th century, and even this century, confirmation battles occur when the Senate is of a different political party than the president. Virtually never will the Senate reject a nomination of the president when the Senate is the same political party as the president. It's when the Senate and the political party are different parties that you have confirmation fights. And I think then you do have a very important check that I think that it was completely appropriate, and I'm very thankful that the Senate rejected Robert Bork. Just think of how different the law would have been if not. He was rejected precisely because of his ideology. And we can go back to others who were rejected because of their ideology. And so I think one of the checks that's built into the system is Senate confirmation. And we just have to realize when it happens is when the president and the Senate are different political parties.
And I think maybe, we can't get rid of Senate confirmation because of the Constitution, but I think an interesting sort of subset of that argument is, what about expanding the nuclear option for Supreme Court nominations? The idea that, right now you essentially need 60 votes to get someone through for the Supreme Court. But, there is a strong argument that the Constitution sets forth majority rule, and maybe we shouldn't have that. Maybe we should, in the same way that right now, because of the deployment of the nuclear option for Court of Appeals judges, maybe you should do that for the Supreme Court too. I think that's sort of that's something that is a possibility under the Constitution. Is an interesting thing to think about.
I think if the Supreme Court retained the kind of power and authority it has now, Senate confirmation wouldn't change, or getting rid of Senate confirmation wouldn't change all that much, because you'd still have, it's the political controversy that happens outside. So the confirmation hearing provides you a place in which to do this and have this pressure. But it's not like presidents would just make the appointments and nobody would care or do anything about it. So you'd have largely the same debate unless something changed about the power of the court, which is...
On that line, Harriet Miers was obviously briefly nominated, and then the conservative legal establishment sort of rose up as one, right, and said, "Not over our dead bodies." And so I think that is a real phenomenon. It's possible that the Senate confirmation process itself intimidates some people who may otherwise be attractive judges. Obviously, Governor Mario Cuomo was very seriously in consideration during the Clinton administration. I don't know what made him back out, but he did sort of play Hamlet there for a very long time, and it's possible that the sort of scrutiny that one is subjected to through that process does make some people say thanks but no thanks.
Is it possible that the court's flaw is not enough power, especially in enforcing its decisions? Case in point, what can the court do to keep Roy Moore and other Alabama state officials from refusing to comply with the marriage equality decision? So the court can't carry out its orders, as we're reminded in history, but should it have some kind of enforcement power?
I think, in some ways, I think the enforcement power is the sort of belief in its legitimacy. And so, if that became further undermined, then I think it would be even harder for the court's rulings to be accepted and followed. Which is not to say we shouldn't criticize the court, but I do think that is sort of the way that when Marbury was decided, it wasn't a given that the court's ruling would be followed, and we have that today. And so I think it sort of goes into one of my reasons for saying that the court as an institution is not a failure.
I think it doesn't need any more enforcement power because it has the lower courts to enforce these things.
And it's interesting, even all the departmental debates that have taken place across, there always has been a general assumption that we'll enforce the judgment in a particular case. So Lincoln ignores Dred Scott in every other context, but says, I would enforce the judgment in the particular case. I just don't have to follow it as a rule for other cases, and that becomes one of the places. Who's going to stick to their guns the longest? It'll force the debate back into politics, and you get the kind of public deliberation that the Constitution is designed to create so that we make the decision.
Here's a question that's really sort of inside the court, but maybe worth throwing out. Should the cert pool be reformed? So everybody here knows what the cert pool is. So I guess 8 of the justices pool their clerks to do the initial vetting of the 8,000 or so cert petitions that come in every year and make a recommendation as to which are worth taking further or which will be subject to the default rule, which is that if nobody's interested, they're just denied. So the cert pool came about in the 1970s and has been subject to various kinds of criticism ever since. Does anybody think that cert pool presents a problem that needs to be reformed?
I think it's partially responsible for the smaller docket. It used to be that every cert petition was read by 9 law clerks, any one of whom could recommend cert. Law clerks would tend to know the issues that their justices were interested in. Now a cert petition is read by 2 law clerks, one for the cert pool and one for Justice Alito, who's not participating. And I think that is a problem, and I think from the lawyer's perspective at least, it would be better to have the cert petition be read by 9 people rather than 2 people.
I'd add one thing to that, which is, I assume this is still the case, it was certainly true years ago, that there's a strong norm in favor of denying cert among Supreme Court clerks. And the reason is, if you goof up and a case is granted and the justices decide that that was an improvident grant, you're not a very popular person. Nobody ever gets criticized for mistakenly recommending a denial of cert. And so that feeds into the problem. And I think it is a serious problem, although one would obviously disappear when the clerks disappear.
Although not clear when I clicked, there were a bunch of justices not in the cert pool, and I think I could say with a fair amount of confidence that a number of them would just read the question presented, and that was what they needed to decide whether to vote for or against cert without looking at all at the underlying petition.
See, maybe this would be our last question. You mentioned some dissatisfaction with the number and types of cases taken by the court. Do you think this is an area where changes could be made, such as a quota for cases per term, or having a third-party entity have some say in which cases are granted cert? So that's the variations of this, not the quota, but the third party, the kind of cert court, has been a recommendation over the years. It kind of came up in the early 1980s when it seemed, or when Chief Justice Berger thought the court was drowning in work. It's maybe less salient today, but
it is fascinating, right, that Chief Justice Roberts, when he was before he joined the court, was very interested in increasing the size of the docket, and since he's become Chief Justice, that has not happened. And so it would be interesting to hear him talk a little bit more about why that is exactly. It's hard to know from the outside. I suspect if there were a quota, that the effect of that would be, if it weren't much higher, that they would take some of the cases that they currently handle in a summary fashion and have argument and briefing on those, even though I'm sure the justices would be incredibly irritated about having to have an hour of oral argument when they're ready to decide it on the merits. And so I don't think a quota is going to come, and I don't think I'm attracted to it, at least to make the justices hear a particular number of cases. That seems odd.
Just observationally, there's kind of an effective quota that consists of the court's calendar. That is to say, you go on the court's website and you see the calendar of, days for argument, days they're going to be on the bench. And the one thing they really hate and fear is a day listed on the calendar when they have no cases, right? That's happened, and they're very unhappy when that happens. So I think we see a phenomenon, for instance, in January, which is the last time to grant cases in the regular order that would be heard in April, which is the last argument sitting of the term. It's a lot easier to get a case granted in January than it might be in, October, November, whatever. So that's one kind of impetus. And I once made the suggestion to some members of the court that if they would only cancel the April arguments and then carry over the cases granted that ordinarily would be in April would be carried over and would fill October, and they would just get a much better flow of cases, and they wouldn't have this problem of having to expedite the briefing schedule in October in order to shoehorn cases onto the January calendar, and I was told, yeah, we hear you, but we couldn't do that because the public would then think that we weren't working hard enough. So should there be a third outside court, a third party that would inform them of the kinds of cases they ought to take and that they're not taking?
Well, I do think there's something interesting that can be learned from the lower courts in this regard. I think especially when so in the cert petition, there's the paid docket where you have, the cases the cert petitions that have lawyers, generally from Supreme Court law firms, and then you have the IFP, the informa pauperis docket, and it's very rare for a case from the non-paid docket to be granted, and I think that's partly because the justices assume, and I think there's some merit to this, that if there is a there in the case, then some eager Supreme Court lawyer will have taken the case pro bono for the cert petition and gotten the case up that way. But I do think that in the lower courts you have panels that will look at some of these cases, and especially if they're not going to be heard for argument, might recommend a decision, and through the staff counsel for the court. And I think that is something to think about for the court when you have largely prisoner appeals that get overlooked because they're not written in a way that the court generally is used to seeing. So that might be one instance where having this sort of administrative body like we have in some of the lower courts might be useful for the Supreme Court.
I mean, to make a recommendation, not to make a
Right.
binding,
Yes.
a binding judgment.
Exactly.
One thing that concerns me about that, and it's a problem with the court is doing now that we haven't talked about, I think there's an increasing number of instances where the Supreme Court is issuing per curiam opinions without briefing and oral argument based just on the petition for certiorari and the opposition to the petition for certiorari. I worry that such a proposal would make that more common, and I think it's a terrible development. As you know, there's an enormous difference when one puts in a petition for certiorari or an opposition to a petition versus the brief on the merits. The petition for certiorari is all about convincing the court this is worth hearing. There's a split among the circuits, an issue of national importance. An opposition to cert is about convincing the court this isn't the right vehicle. And when the court's deciding without briefing on the merits and oral argument, it's really making a decision without what it needs and what we believe is necessary for judicial decisions. And there's been a lot more of that in the last few years, and I worry a proposal like this would even increase it further.
Well, I think that's a very good point, and I think going back to, maybe we'll close with, back to Larry's initial point about the lack of transparency. If there's one instance of a lack of transparency, it's a per curiam opinion that's a binding decisional judgment off the cert list, which is problematic for exactly the reasons that you say.
It's not that it's per curiam. The problem is that it's a summary. A
That's what I
summary
mean,
judgment,
summary.
I thought, was your point, not that it was per curiam.
Yeah, summary without having notified the parties that the case was up for decision on the merits, as opposed to just decision on whether to take it.